Good evening, everyone. Good evening, ladies and gentlemen. On behalf of the Heidelberg Center for American Studies, it is my pleasure to welcome you to tonight's lecture on Friend or Foe, the U.S. Supreme Court and American Democracy by Professor Emma Long. Our speaker comes to Heidelberg from the University of East Anglia, Great Britain, where she teaches as an associate professor in American history and politics at the School of Politics, Philosophy, and Area Studies. She received both her undergraduate degree and her PhD from the University of Kent, and she also spent a year at the University of Wisconsin-Milwaukee. Her CV indicates she's a Packers fan, right? In 2013, she joined the University of East Anglia, where she has since taught. Let me also mention that Emma Long has served as both vice president and president of the American Studies Network, an association of American Studies centers located in Europe, and I understand the HCA is also a member. Emma Long's research interests focus on two major areas: the history of the United States Supreme Court and the relationship between religion and the state in particular. And secondly, she has worked on American evangelicalism, especially on its impact on American politics since the mid-20th century. Her work on these two topics has resulted in two major books: her 2014 monograph, and I quote the titles, "The Church, State Debate, Religion, Education, and the Establishment Clause in Post-War America," as well as her forthcoming book. The title is "Lobbying for the Lord," no fear of alliteration here, "The National Association of Evangelicals and the Growth of Post-War Evangelical Political Activism." In addition, she has edited several essay collections and authored numerous journal articles and book chapters which cover topics such as reproductive rights, gun rights, and issues of religious freedom, among others. Her talk today dwells, I understand, on an ongoing project entitled "Politics, Democracy, and the U.S. Supreme Court," in which she places current debates about appointments to and decisions of the Supreme Court into a broader historical perspective. Ladies and gentlemen, I think there's no need to emphasize the timeliness of Emma Long's talk this evening. At a time when Donald Trump is trying to establish the rule of what I would call presidential authoritarianism, the Supreme Court becomes a crucial player in either setting limits or lending legitimacy to Trump's power grab. As of now, the verdict is not yet out, although I admit I'm not particularly optimistic given the 2024 precedent in Trump versus United States. But of course, the Supreme Court and U.S. democracy is a topic that has a long history, and it transcends recent controversies. Indeed, the very idea of a constitutional court claiming authority to void acts by democratically elected legislatures has always been repugnant to critics who insist on popular sovereignty and legislative supremacy. It is also important to remember that charges of judicial overreach have come from both the left and the right. When the court was advancing civil rights and liberties in the mid-20th century, it became the target of sharp criticism from segregationists and law and order conservatives, respectively. Since conservative justices have dominated the Supreme Court, it's now liberals and progressives who demand judicial restraint and complain that the court is part of a counter-majoritarian system ensuring minority rule. In assessing the historical role of the Supreme Court in protecting and threatening democratic government, an expert look is urgently needed. The HCA is therefore delighted that Emma Long has agreed to this lecture tonight. Let me add, with great joy, that her stay at the HCA is somewhat of a reconnaissance mission, because I can here announce that Professor Long will spend more time at the HCA later during the summer semester as a beneficiary of Heidelberg's program Expanding Internationality. She will teach a class on crime and punishment, a history of American criminal justice. And she will hopefully explore opportunities for future cooperation. I'm sure we'll find many colleagues who are more than eager to talk to you. We are very much looking forward to your extended stay, but for now, we're eager to hear what you have to say about the U.S. Supreme Court and American democracy. Emma, the floor is yours.
Thank you very much for the warm welcome from everybody, and I'm very excited to be coming back in the summer. Hopefully I don't bore you all tonight and therefore you just wish I'm not coming back. I'm going to set my timer here because I'm a bit of a Supreme Court geek and I have a tendency to waffle on. I will talk about the Supreme Court until somebody stops me. So I'm going to set my alarm to make sure I stop on time. Okay, so this is part of a project that's very much in progress at the moment. So you're getting a sneak peek of things that I am really beginning to think about. So any comments or questions or thoughts or feedback on anything that I say tonight is more than welcome because everything is still in the process of being worked out. Okay, so, apparently better. Okay. In 1936, Ernest Bates called the Supreme Court the supremest Supreme Court in all the world. And what he effectively meant was that the US Supreme Court, in the system of government as it is, as one of three co-equal branches of government, gave it more power than high courts in other countries, and sort of a more significant place in the broader governmental system. Past Supreme Court rulings, he also noted, had also given the Supreme Court a degree of power and influence that were not necessarily available to other courts. Building on that, I would argue that actually the American public have also given the Supreme Court a degree of power over the last 70 years or so at least. We can talk about why maybe afterwards, but the American public have increasingly looked to the Supreme Court to answer issues that in other countries would probably have been decided by legislatures and in some cases perhaps would have been better to have been decided by legislatures. As a result, the Supreme Court has rarely been out of the headlines, and this higher profile has, of course, set the court up for higher levels of criticism. Criticisms have come not only, as we might expect, from the public, from the media, from politicians, but also from academics who have, in the last 20 years or so, written books with the titles called such as Unfit for Democracy, The Spectre of Dictatorship, and no fewer than 2 books titled Stench, which is not something you really want your institution to be described as, it seems to me. Now, I've studied the Supreme Court since my year abroad of my undergraduate degree, which is coming up for 30 years now. And watching the Supreme Court over the last maybe 4 or 5 years, something along those lines, I kind of got this sense that there's a greater threat to the court as an institution from both internal and external forces than at any other time that I had studied. So this project comes really as a question out of my gut feeling, trying to interrogate that. So is the the purpose of this is to think about, is the Supreme Court under greater threat? Or is it simply the fact that we're going through a period of uncertainty and we don't know how it comes out? I'm a historian by training. I sometimes pretend that I do politics, but really I'm a historian. I'm used to studying things where I know what came afterwards and knowing that somehow, eventually, it worked out. We don't know that yet. So is it part of just my uncertainty as well as everybody else's? So this is what I'm looking for. My provisional conclusion, in case I run out of time, my provisional conclusion here is that all of these debates are part of a much longer ongoing conversation about the role of the Supreme Court in the American system of democratic government. It's a role that is not set out in the Constitution. People are often surprised about how little the Constitution says about the Supreme Court, given how much power it has in the modern day. It's mostly established by practice and precedent. And so, as a result, it is constantly up for debate. Where does or should an unelected, potentially unaccountable judiciary stand in relation to the elected branches of government? Or, in fact, if you want to ignore the government, how far should it stand as against the will of the public or the will of the majority? These questions, as in the current moment, have a tendency to come to the fore at times of political upheaval in the United States. Because at that point, almost everything is up for grabs. So in this particular paper, I want to think a little bit about why we've got to the position that we're in at the moment, and how some of these debates have been reflected in similar historical contexts, or at least similar debates over time. And if I have time, if I don't go off script and if I don't waffle too much, I will try and talk a little bit about what I think might just be different about the current moment as a way of thinking about maybe my gut instinct isn't completely wrong here. Feel free to challenge me on that afterwards. So the current moment, let's start here. Let's try and give ourselves some context. How does this come about? How am I expressing concern about this? There are a number of factors that play into this, it seems to me. The increasing partisanship of American politics generally, a winner-takes-all approach, and portrayal of enemies as enemies, as an existential threat to the other side's way of life. In constitutional terms, an existential threat to the United States and what it stands for. It seems to me this is a recipe for tension, and if you're working in the field of American studies, you can't escape talking about partisanship at the moment. The court is not separate from that in any way, shape, or form. Also, by President Trump's behaviour, both as president and as former president, towards members of the judiciary and their role. I don't know, I think maybe the text is too small to read from there, but starting right back from when he took office in 2017, which is where these examples from Twitter, you can tell it's a long time ago, they're from Twitter, not X, attacking judges. Attacking the role of judges, attacking them as being biased when they rule against him, and supporting them when they rule in ways that he likes. By the 6-3 Conservative majority that was created during Trump's first term, by behaviour that might fairly be criticised in terms of not playing by the rules, or at least playing by rules interpreted in a slightly questionable way. It is currently the most conservative Supreme Court since the US in the 1930s, and we'll come back to talk about the relevance of that period. Rulings in particular cases that have led to dissent The most obvious one, I think, is probably Dobbs versus Jackson Women's Health Organization from 2022, which overturned Roe versus Wade and access to abortion. Trump versus the United States from 2024, and questions of presidential immunity, but there are many others that we could talk about. There are claims that the Supreme Court is destroying democracy, that it is dangerous, that it is too political, that it is too conservative, amongst others. And this is in part driven by comments by politicians and, I hate to say it, the media, who portray the court in increasingly partisan terms. I will not get on my soapbox and explain why I think that's a bad thing. That's a talk for another time. All of this is reflected in a fall to historic or near historic lows of public approval ratings of the court. According to the Pew Research Centre, it sits at about 50%. According to Gallup, slightly lower at 42%. And while I suspect Congress and the executive branch would really rather like approval ratings at this kind of level, this is extremely low historically for the Supreme Court, although you can see in the graph here on the other side of the screen, responses depend in part on the politics of the people responding, which perhaps should come as no surprise. Now, this reduction, this drop in public support for the court might well be linked to this graph, which suggests that 60% of Americans, or at least respondents to the poll, indicated that they thought the court was too political. The majority of those classed as too conservative. Some suggested the court was too liberal, but the idea that the court is political has gained traction in many ways. Now, many, if not all of these things are linked to the changes wrought by the Trump administration and by Trump's 3 appointments to the court in his first term, which obviously shifted the court from what had been a nascent, sort of emerging conservative majority to an unquestionable 6-3 one. But a change of ideology in and of itself isn't new on the Supreme Court. Okay? From the early 20th century until 1937, the Supreme Court was dominated by conservatives. And I should probably make clear, when I talk about liberals and conservatives, I'm talking about legal liberals and legal conservatives, not necessarily political, although there are overlaps between the two of those things. So there's a history of the Supreme Court being conservative, and you could argue that actually the Supreme Court has spent more of its history being conservative than it has being liberal. The shift is also not new. From the 1930s into the civil rights era, the Supreme Court shifted from conservatism to liberalism. And although that is a shift in the other direction here, it is a shift nevertheless. The country survived both of these things, which should give us hope that it will survive the current situation, but doesn't necessarily tell us much about why or how or with what damage or with what controversies happened in the meantime. This drop in public opinion is important because, using the arguments of Alexander Hamilton, the Supreme Court can't force anybody to follow its rulings. It doesn't have the power of the purse to pay people, doesn't have the power of the sword to coerce them into doing things. It relies on its ability to convince people that its rulings are legitimate, even when they disagree with them. This drop in public opinion, previous graph, runs the risk of damaging the court's ability to do that. And this is important whether you fall into a liberal or conservative category. The damage to the court as an institution runs the risk of preventing it from doing its job, and that affects everybody, which I think is why this is an important thing really to look at. So to give you a sense of how this all fits into the project as an overall thing, I'm running behind here. Here we go. So the larger project looks at the Supreme Court in 4 periods of conflict and crisis across the 20th and into the 21st century. Times when the Supreme Court has been caught in the crosshairs of political debate that is going on more broadly in the country. And you can see them here. Sort of roughly the progressive era, the first couple of decades of the 20th century, the New Deal era of the 1930s and into the 1940s, the Civil Rights era of the 1950s and 1960s, and then the current moment. All of these things are very different in some ways and very similar in others. It is a period of political turmoil where Americans were asking questions about what their nation is, about what the nation stands for, about what democracy in those periods mean, and particularly in the first two, although to some extent in the third as well, questions about what the power of government is and what it should do. The specifics of all of these are somewhat different, but those things link them together. And the nature of the law is that it has winners and losers. This is why I think a lot of these issues would have, in many cases, would have been better dealt with by legislatures that deal by necessity in terms of compromise and the grey areas that come in between. Law largely requires a decision one way or the other, which often makes it look as though the Supreme Court is putting its thumb on the scales of an ongoing political debate, which is where some of the controversy tends to come from. And this happens in all four of these periods, including the current moment. Okay. I think everything is... I will not bore you with necessarily details of everything, all the details that are going on here. Needless to say that each of these invariably draws the Supreme Court in. In the progressive era, sort of not exactly inadvertently, but as a result of questions about government power. From the 1930s onwards, participants increasingly consciously use the Supreme Court as a way to litigate issues to gain traction in political debate. So they are drawing the Supreme Court into political battles, often quite consciously. And this is another reason that puts the Supreme Court in the middle of these debates. It's not the court necessarily choosing to put itself there. The Supreme Court is a reactive institution. It can only respond to the cases that are brought to it. If through political action those cases have political consequences, then the court inevitably gets drawn into these debates. And this is what's happening at most of these periods of time. Okay, so to move on and look at some of the comments, some of the criticisms, some of the issues that are raised, thinking about criticisms or comments about the Supreme Court today and their historical comparisons to see where there are similarities and differences. So in 1962, political scientist Alexander Bickel wrote about what he termed the counter-majoritarian difficulty of the Supreme Court. The idea that unelected judges could overturn the will of the people, as expressed through legislation, if they found laws to be outside the power granted by the Constitution. Just heard about that a minute ago. Now, ultimately, Bickel sort of backed away from the potential consequences of his argument by saying it didn't really matter because ultimately, if you looked at what the Supreme Court did, eventually it sort of followed public opinion. It might have taken a bit of time to get there, and sometimes there was a delay, but ultimately, when you looked at the court, it never stood in the way of the will of the popular majority for very long. I'm not sure if that's always entirely true, but he was part of a school of thought that was very much thinking that way in the 1960s. But at the core of Bickel's argument, if you take away his "it doesn't matter because it follows public opinion," is kind of the heart of many of the questions and concerns and criticisms offered at the court across the 20th century. Effectively, to what extent should the Supreme Court have the power to overturn actions that have effectively the support of the public and have been passed through democratic processes? Which is what the court can and often does. Now, I think probably the first place to start is to recognise that this is built into the Constitution itself. Right? The framers were famously wary of unbridled democracy. This is where we get the checks and balances between the branches of government, which includes the Supreme Court as part of that. So unelected judges are part of the design of keeping democracy in check and preventing it getting out of traction, or getting out of control. And often when there are these political debates going on and people are sort of arguing that the Supreme Court should follow the public will, they have a kind of tendency to forget that this is kind of what the framers intended, even though they might quote the framers endlessly at other points. Inconsistency in these arguments is fairly common. So, for example, to give you some examples that have come up in my research so far, in the early 20th century, the Supreme Court was criticised for overstepping its bounds and unconstitutionally limiting the powers of states to try and rectify what they saw as the worst excesses of the new industrial urbanised economy, the kind of growth of mass capitalism that had emerged from the late 19th century. The justices of the court declared leading progressive senator and former Wisconsin governor Robert La Follette in 1912 were, in his words, usurping the power to declare laws unconstitutional, and they had, he argued, become in reality the supreme lawmaking and law-giving institution of our government. They have taken to themselves a power that it was never intended that they should exercise. And this becomes the debate. Do they have the power? Was it intended? Should they have it? So he got to the heart of the argument, although he was taking the view that what the court was doing was wrong. Then in the early 1930s, the Supreme Court struck down, at least initially, much of Franklin Roosevelt's New Deal legislation, which was designed to try and address the emergencies of the economic situation emerging from the Great Depression. Journalist I.F. Stone lamented that, in his words, the court now acts as a third house of Congress, as a super legislature, as an American House of Lords, and no longer as a court. So again, this idea that it's stepping into the legislative realm and superseding their power. Celebrated journalists Drew Pearson and Robert Allen described it thus in very colourful language. They wrote of 9 black-gowned Beatles, aloof from all reality, meting out law as inflexible as the massive blocks of marble that surround them in their mausoleum of justice. They're brilliant. They wrote a book in the 1930s called 9 Old Men, which was a huge criticism of what the court was doing in terms of the New Deal. It was based on a slightly scurrilous Washington newspaper column that they had called the Washington Merry-Go-Round. And the book is just full of language like this. It's just a fabulous read. If you're interested in the Supreme Court or journalism covering the Supreme Court, it's just brilliant. I would highly recommend it, even if you don't agree with their politics. It's kind of a fun read. But again, what we're seeing is this criticism that the court is stepping beyond its bounds. In contrast, and kind of in a reversal, during the civil rights era, critics accused the court of getting ahead of legislatures, not getting in the way and stopping them doing it, but getting ahead of legislatures, of making decisions that the legislature should have been able to do, and enforcing decisions on states and the people that they didn't want, that they shouldn't be forced to accept, but because they were making constitutional decisions, they were required to do. Now, this included desegregation, of course, but also towards the end of the period that we're thinking about, abortion, Roe versus Wade and abortion law, which probably mark the two ends of the period that I'm thinking about. Now, in this period, evidence suggests that the critics were wrong, and that actually, even if just a narrow majority supported the things that the court was doing. But conservatives since have argued that much of what the Warren Court did was wrong, that it was judicial activism, that it went beyond the power of the court, that it was anti-democratic. And one of the reasons that we are where we are today is the backlash to this particular period, particularly legally. There's a whole really interesting history on the conservative legal movement. But in terms of this, it's what I'm talking about today. It's the argument that the Supreme Court stepped beyond its bounds that conservatives today are arguing gives them the legitimacy to roll those things back, even in cases where people have come to rely on the existence of those rulings. Ultimately, the thing that's really important is that none of these battles were resolved. In the 1920s, the economic boom shifted attention away as almost everybody's standard of living began to rise. People began to think of other things. In the 1930s, the Supreme Court ultimately started upholding New Deal legislation. And then, of course, the American public were distracted by the outbreak of World War. In the 1960s, it was the Vietnam War and Watergate which shifted attention away, and the Supreme Court became more circumspect in some of its cases, so it's not making the same kind of headlines. But ultimately, if you like, the big argument here is that the American public have never fully got to grips with the question about the place that the Supreme Court should have, or at least never quite fully got comfortable with the idea that the Supreme Court might stand up against majority public opinion, especially from those who form the majority at the moment that it is being struck down. Now, this may well be because each generation has to renegotiate what this means, but ultimately those discussions aren't necessarily being had openly. They're sort of covered up in other debates about the law, about politics. Okay, so this is one area of similarity. Second one, the idea that the Supreme Court favours special interests. So, as you can see, carved into the Supreme Court building right over the top is equal justice under law. It's a fundamental principle of the rule of law system. So, of course, attacking the court on the idea that or accusing it of favouritism or favouring special interests, taking sides in political debates, is effectively one way of undermining Supreme Court rulings if you want to attack them and say that they're wrong. And we see this across every period. So recently we've seen it come up in a couple of ways. Ethics criticisms of the Supreme Court justices. So Justice Alito's wife flying the Appeal to Heaven flag, Clarence Thomas's wife being involved potentially in the campaign to overturn the 2020 election and other things. But it links into a broader criticism that the justices aren't making decisions on law, but they're making decisions on either personal politics or in return for favours. So effectively bribery. The second criticism is that the Supreme Court's approach favours the Republican Party. This is slightly more diffuse argument, or according to a recent study published by economists at Yale and Columbia, that ultimately the Supreme Court favours the rich, which is an argument that the progressive era would have been found extraordinarily familiar. Given what I'm talking about, you will not be surprised to hear that I'm going to tell you that this isn't new either. If you go back to the 19th century and think about the period before the Civil War, the battle over slavery played out within the Supreme Court because there were justices that were slaveholders and justices who were anti-slavery, and so you get that battle going on between them. In 1968, there are allegations of ethics violations. Justice Abe Fortas misses out on the potential appointment to the role of Chief Justice because of concerns about his finances that would seem fairly mild, I think, in the context of allegations to today. But these things have been around and offered up to the justices in the past. As I said, in the early 20th century, Supreme Court critics accused the justices of being too friendly with business and too willing to protect business independence at the cost of ordinary American citizens. You're failing to stand up and look after the little guy, ordinary working people. Social reformer Jane Addams commented on working class views of judges generally. His sympathies and experience and his whole view of life is on the corporation's side. You can tell it's the early 20th century because the automatic assumption that judges are male here, use of his. Johns Hopkins political science professor Walter Dodd observed that the justices, in his words, are quick to declare unconstitutional almost any laws of which they disapprove. And progressives consistently accused the court of favouring, when you looked at things like laws about union controls, about working hours legislation, about maximum hours, anything that seemed designed to improve the lot of working people, that the Supreme Court stood in the way and said no. ultimately everything favoured the business world. It wasn't helped by a kind of favouring of laissez-faire economics, which is sort of the 19th century hands-off view of the economy and government, which favoured the status quo in this particular instance. Similar comments, particularly around the same issues, emerge around the New Deal, especially positions of economics, although this, I would argue, overlooks the fact that if you look at some of the earliest New Deal decisions that strike down some of the early core tenets of Franklin Roosevelt's program, you'll see that it was a combination of conservatives and progressives. Some of those decisions were unanimous. Roosevelt tried to ignore that fact. But I think actually it's important to remember that New Deal legislation was not just struck down by conservative justices. And I think it's important, particularly in the context of the moment. So this somewhat complicated graph, we're really just interested here. Breaks down the way in which Supreme Court decisions have been made and how many justices form each side. So thinking about the last full term, the one that ended in the summer. A third of the Supreme Court's cases, so 22 out of 62, were decided by a 6-3 vote. And so the ideological balance that's currently on the court. But only half of those, so 11 of those cases, were decided along conservative liberal lines. So, which means in the other half, 2 or more conservatives had to join up with the liberals to lead to a different result. So 82% of the work of the Supreme Court in the last term did not fall along ideological lines, which is not the dominant narrative. And I think it's important to remember, even as we also remember that almost all of those 11 cases were fundamentally significant cases. Right? I don't want to downplay the significance of them. I just want to make the point that when we talk about the court being political, we're not necessarily talking about every case that is decided by the court. And I think that is worth remembering both historically and today. Moving away from the specific politics of any particular moment, there is this larger question about how far law and politics are separate, and how far judges, when interpreting the law, should be neutral, or at least as close as we think is possible to this. And this becomes a debate that flows through many of these periods. But and today I think we would see the argument that we would want judges to apply the law in a balanced way. But historically, this has run into trouble and run into resistance. So in the early 20th century, for example, progressive reformers criticised judges for what the Dean of Harvard Law School, Roscoe Pound, called mechanical jurisprudence. So the idea of taking rules and laws and constitutional provisions and applying them in this kind of this way that didn't take account of the context or the way that they actually worked in practice, the impact that they had on the people who were subject to these laws, seeing them kind of as this intellectual exercise outside of it. To go back to Robert La Follette, who said, "The regard of the courts for fossilised precedent, their absorption in technicalities, their detachment from the vital living facts of the present day, have brought our courts into conflict with the democratic spirit and purposes of this generation." I would argue there are familiarities here with debates currently about the way the Supreme Court is applying and understanding things, say, about minority voting rights and gerrymandering, for example, about reproductive freedoms, about transgender protections, amongst others. So there are echoes here. Instead, those of the legal realist movement, people like future Supreme Court Justice Louis Brandeis, advocated for what they called sociological jurisprudence, which, when you break it down, is effectively you need to understand the law in the context of how it actually works. You need to look at the big picture to see what's going on. I'm trying to take that to heart in the bigger project placing the court decisions in their legal and political context. I would hope Louis Brandeis might approve, at least of the method. So effectively, the point here is that progressive justices and those who supported sociological jurisprudence did not want the judges to apply things in a neutral way. They wanted them to take account of the circumstances. And here's part of the problem. That critics actually at the time and subsequently have pointed out in many of these debates, Americans want and expect principled decision-making from their justices. Okay? It seems fair. You don't want them just going, well, I like this person and I don't like that person, and therefore you win and you don't. But at the same time, they want decisions that favour the outcome they want. Right? So they want principled, but they want the results. They want the favourable results. And this is a tension at various moments in time. Inevitably it's going to be, because you can't please everybody all of the time. And in periods of tension, when you have more or less equal numbers on both sides, you are going to upset one side or the other when you ask the Supreme Court for a ruling on something. So this question about how much politics Americans are willing to allow or willing to accept in Supreme Court rulings is something that also has not fully been discussed openly or resolved within the US. My final comparison here has some links to where we started in the first point about democratic governments, but focused more on the Supreme Court as an institution. Particularly when it chooses to act or when it chooses not to act. So Justice Thurgood Marshall quite famously said that deciding not to decide is one of the most important things done by the Supreme Court. Choosing not to get involved, not to make a ruling, can often be as significant as not. And when I'm talking to my students about the court, I always say, ask why this case and why now? Because they're not necessarily the first time these cases come to the Supreme Court. Quite often they've turned down similar cases. So there is a reason why they accept them at a particular moment in time. And trying to understand that helps us understand what the court is doing. Thinking about it in the current context, since the 1950s or so, conservatives on the court were considered conservative because they advocated judicial restraint. The idea that there were some issues that the Supreme Court should not get involved in, that it wasn't their place. And that they would be better decided by the political realm for a variety of reasons. But what we've got now is 3, possibly 4 conservative justices who believe that their role is to right the wrongs that they see in previous law. So I'm thinking particularly about Samuel Alito's comment in Dobbs versus Jackson Women's Health, where he said that Roe versus Wade was egregiously wrong, and effectively all the court was doing was overturning something that should never have happened in the first place. There's a similar ruling in a case last year, Loper Bright Enterprises versus Raimondo, which was about Chevron deference, previous case, about how far the government should and courts should give deference to executive agencies making decisions about how to apply the law in their area, which sounds really quite dry and technical, but is really important about the power of the federal bureaucracy to do its job, and really didn't get the kind of coverage outside of the US that I think it probably should have done, particularly in light of some of the cases that are coming up. Importantly, I think those taking these views and thinking about the current court, those taking this position are not all the Trump appointees. It's not just that Trump appointed 3 people and this is what they're doing. In fact, those leading this charge are Clarence Thomas and Samuel Alito, who were appointed before Trump, although what seems to have happened is that they've given, the new appointees seem to have given them confidence that they've got a majority and therefore they can push ahead with this particular agenda. But it's this idea, I think, that they are righting the wrongs of the past, that this justifies conservative judicial activism, when in the past conservatives would largely have argued for judicial restraint, that is particularly important to think about it. As we've seen in the Progressive era and also in the New Deal era, critics argued that the Supreme Court was getting in the way and the will of the reformers who were looking for change. Sociological jurisprudence, people like the great legal mind of Oliver Wendell Holmes, argued democracy was what the majority wanted and the Supreme Court should defer to that. And it was the liberals that wanted judicial restraint. Right? The liberals were saying, no, we shouldn't be getting involved in this. We should be letting legislatures get on with what it is that they should be doing. That switches in the civil rights era, where it's the liberals being activist and saying, we want to change. We think that the court has a role in reforming society and playing the role. And there were reasons for that, mainly because legislatures weren't responsive. But what you see is a shift. So conservatives are now advocating judicial restraint. Liberals want judicial activism. And now we're back to where we were. Now the conservatives are activists. The liberals want judicial restraint. And the risk here is that instead of being an argument about the reality and the importance of these things, they get so caught up with the politics of the moment that it's difficult to disentangle them. How far is somebody really arguing for actual judicial restraint at an institutional level, and how much is it because they just don't like what the Supreme Court's doing right now? And these things often don't get pulled apart as often, I think, as they should if you want to try and understand what the court is doing or what the Supreme Court should do, or what even Americans want the court to do at any moment in time. And like I said, it's worth noting that the conservative judges on the court now are really only doing what the liberal Warren Court did in the 1960s. The people who like what the Warren Court do are now saying that the court is doing the wrong thing, and vice versa. If you can step away from the politics, there's a degree of hypocrisy going on there. I mean, I don't like what the Supreme Court is doing politically. It doesn't align with my politics or what I would like them to do. Do I think that as an institution they're standing outside their powers? That's a harder question to ask, trying to separate my own views, my own political views from my sense of what the court is as an institution. Some have tried to argue, actually, in defence of the court, that it's not as activist as people seem to have the impression about. So a series of articles written by conservative legal scholar Jonathan Adler, particularly called the Imperial Supreme Court. You see in this an online blog, presents this graph to show effectively that the Roberts Court is striking down past cases at a much lower rate than the previous courts that weren't quite so criticised for being activist and so on and stepping backwards. And so he wants to argue that the court isn't moving as far or as fast as critics suggest. Now, there is something in this, but to go back to a point that I made earlier, what it doesn't take into consideration is what precedents are being overturned. It doesn't make a distinction between overturning something that interpreted an ordinary law that Congress can reenact and therefore overrule or modify, and overturning constitutional decisions which require constitutional amendment or convincing the court to overturn itself. So there is huge significance here that his articles simply do not address, and that I think are important to this overarching sense of how far the Supreme Court is being activist. Which sort of brings me to a point I've already kind of touched on, but sort of to make explicit, the idea that the Supreme Court is changing its mind, that it's going back, it's rolling back decisions that people have come to rely on, and that this is somehow illegitimate. Perhaps it is, but it has also happened before. The Supreme Court famously, within the space of 4 months, went from having overturned 10 of 12 pieces of New Deal legislation to upholding every piece of New Deal legislation that came before it. And if I remember the numbers correctly, between 1937 and 1946, it overturned 32 of its own core precedents. It massively backtracked. Now, there is a complicated narrative that goes beyond the simplistic one that Franklin Roosevelt threatened to pack the court and then and they went, oh, no, you can't do that, and changed its mind. There is much more going on in that particular situation than that argument. Also, after that period, the Supreme Court fundamentally shifts the underpinnings of its arguments and takes a different approach. Civil rights, civil liberties become a much bigger focus of the Supreme Court, and the way in which it approaches decisions changes. So again, case that almost nobody has heard of. Here we go. US versus Caroline Products, talked a lot by legal scholars, basically unknown amongst everybody else. This is footnote 4, second most important footnote in Supreme Court history after the one in Brown versus Board of Education. Basically says that the Supreme Court is going to start paying more attention to rulings that target minority groups. It is the underpinnings of the entire civil rights course of Supreme Court decision-making, and all in a footnote that when I give my students the case to read without telling them why it's important, they miss completely, because nobody ever reads the footnotes. So if you take anything away from tonight, make sure you read the footnotes. They can be important. Okay, I am running out of time here. So, very quickly, what's new? So basically I've spent this entire talk telling you why I think there are similarities between the current moment and why maybe my gut instinct is wrong. That there have been these debates in the past, that this is part of an ongoing conversation, that the Supreme Court has survived, the United States government has survived, and likely will again if those lessons are to be drawn. So why do I still feel uncomfortable in some ways about this? Why do I still feel concerned for the institution I've spent 3 decades studying? First, the politics of the current moment and the partisanship. For the first time in American history, all the conservative justices on the Supreme Court were appointed by Republicans, all the liberals were appointed by Democrats. Add to that the bitter divides at political level between Democrats and Republicans by the way in which the appointment process has become increasingly politicized. That's not just about how the Trump administration handled the appointments in 2016 and 2020, but has been a gradual process that's been happening for at least 20 years at this point. It opens the court up to criticism that it is making partisan political decisions. And actually, lazy commentary, politicians adding to this, the media playing into this has all added to this. I think it raises the stakes in the same way that the politics of the current moment have been raised. Second, the rise of something that you may have heard of called the shadow docket. So there's a big debate at the moment over whether it should actually be called that, which is interesting in and of itself. But this is the way in which the Supreme Court deals primarily with emergency applications, things that need a very quick ruling, maybe to stop something going into effect before it can do any damage, before the whole process can be heard. So the best example I can give you that isn't like a narrow legal technical one is death penalty appeals. They tend to come through the court's emergency docket because if you execute somebody and then you find that maybe there was a problem in their conviction, it's a bit late to do something about it. Right? So the emergency docket historically takes on things like this, and the idea is to give the process time to go through the full process of being considered. Increasingly, the Supreme Court has been making decisions through this way on substantive issues that have had huge impact in ways that it does not. And the big difference between the emergency docket and ordinary opinions is the emergency docket, the Supreme Court does not have to provide an opinion. It doesn't have to explain why it did it, what it was doing, what its rationale, it just does it. Whereas in fully briefed cases, it has to write an opinion and does so in increasing number of words. Brevity amongst Supreme Court justices would be nice. I always get it wrong, but I think it was Oliver Wendell Holmes who always used to write his opinions at a standing desk. And his famous quote is something like, "Nothing encourages brevity like a little weakness in the knees." And I think some of the current justices would benefit from that. Okay. And the third element, which is sort of where I started. So in the 1930s, Gilbert Rowe, who was a liberal activist, wrote this: "The litigation of this country is becoming more and more quasi-political in character, involving questions of government policy concerning which the people have the same right to be heard that they have when the Congress passes upon the same or similar measures." He's criticising the idea that the law was being used for overtly political purposes, what we might now call lawfare. You know, can't get the decision from the legislature that you want, take it to the courts, force it that way. Started for quite legitimate reasons, I would argue, with the civil rights movement and the approach of the NAACP, trying to get around recalcitrant legislatures that wouldn't take their arguments for desegregation seriously. But it has massively expanded and now is used by people who, for whatever reason, choose not to go through the legislatures. The result of this is that the very law has become politicized. Conservative activism in the last 40 years has sought to, in many ways, politicize the way in which the law works. So inevitably, the results from the Supreme Court seem to be political because the law is increasingly moving in that direction. As it currently stands, those are the three things that I think are largely different about the current moment and which I think potentially raise risks to the court as an institution and therefore its ability to play a role, the checks and balances role in the American system of democracy. Okay. I have exceeded my time, so I will leave it there. Thank you for listening. Okay. So I believe we have time for questions.
Well, thank you. And there's plenty of time.
Excellent.
For questions. So I think many of the points you wanted to make will still time.
Excellent.
The floor is open.
Hi, thanks so much for this awesome talk. It's very interesting and proud tradition of checks and balances and balance of powers and those sorts of things. One question I did have, though, you mentioned negative public support up front and the polarization of politics as it exists today. How do you assess the impact of that if power to transition back and related to the expansion of the court to go and rebalance that narrative?
Sorry, I missed it. So what might happen if with the politicization of the law?
So if political power were to transition back, or when that happens, how do you assess that and public opinion related to potentially expanding the court to rebalance to
expanding the court?
Exactly.
Yeah. The issue about expanding the court is very dangerous ground, as Franklin Roosevelt found out in 1937, right? He was elected with this enormous mandate in 1936, and I think thought that he had ground, the New Deal was hugely popular, the Supreme Court was deeply unpopular for striking down. I think he thought he was onto a winner, that this wasn't going to cause him any problems. And there was this enormous backlash. And I think it comes down to this sense that the American people as a whole, tend to get really deeply uncomfortable if you put the Supreme Court and politics too close, which is weird because they also say that they think the Supreme Court is too political. So this whole project is full of these weird contradictions that I'm still trying to work out how they exist side by side. But they don't like the idea of people playing politics, sort of playing blatant politics with the court. And I think we saw a little bit of that, particularly in 2016 when the Republicans held off hearing on Obama's nomination of Merrick Garland to the court. We saw it in 2020 when the White House pushed through Amy Barrett's nomination because despite what the Republicans said, it was so blatantly political. And I think almost everybody saw through that, right? So there was criticism of that, which gives rise to the push for expanding the court when Biden is elected in 2020. I think the reason that didn't go anywhere is that Biden generally understood that there's no public appetite for it.
But what about term limits? What about term limits? Clarence Thomas, if I remember correctly, is now in his 36th year.
Close to it, yeah. He's almost, I think he's very close to being the longest serving in American history.
Amy Coney Barrett is, how old is she in the late 40s?
Yeah.
So,
Yeah.
good health, presuming she might be there for a long time.
Yeah, this is a big change. Actually, being appointed to the Supreme Court used to be the pinnacle of somebody's career, right? And now it's happening earlier and earlier. Term limits is the one reform on the Supreme Court that gets a public majority in terms of polling, because it applies equally to everybody, and it doesn't necessarily seem to be liberals trying to get more liberal justices on the court, conservatives getting more. And it has been consistently proposed in all the periods that I am talking about when people talk about Supreme Court reform. Term limits comes up. Packing doesn't, but term limits do. And I think there's reason to think that wouldn't damage the court, would actually be beneficial in keeping it out of some of the politics of this. But I don't see the political will to try and pass it. And so, good idea, probably. Practical idea, probably not, unfortunately.
Yeah, thank you very much. I think you made a very compelling point about sort of the pendulum of activism swinging between back and forth between left and right, conservative and liberal. On the other hand, when looking at a decision like Trump versus United States, this is not a question of left and right, conservative or not. This is a question of checks and balances and dismantling basically the restraints on presidential power. So how would that fit into the narrative that there is a pendulum swinging to both sides when we actually see that it's about democracy? Democracy is on the line here, the fundamental principles of American government, and not just a question of conservative ideology or liberal ideology.
Yeah, it's a good question. Thank you. And to some extent, something I'm still working out in terms of the contemporary moment. In terms of the in terms of the, if you like, the commentary on that decision, of course, one of the biggest criticisms from liberals was that this was a conservative Supreme Court protecting Donald Trump, right? In the context of that case, I genuinely don't think that was the case. If you bear in mind that during the election, Trump had threatened to prosecute Obama and Biden and others. And so you could potentially interpret the decision in the context of protecting presidents generally, not one individual president. There's a trend, or potentially a trend, I think, emerging on the Supreme Court at the moment. And some of how far this is going to depend on decisions that are currently pending before the Supreme Court, before we know how deep that's going. Right? The one about tariffs, which everyone is hoping is going to come down sometime soon, but probably not before the end of February. And also questions about the extent to which Trump is able to fire heads of executive agencies, right? The Federal Trade Commission, and I forget the other one just now. But the court, a bit like Congress, and Trump versus US is an example of this, is that the court has been moving towards an understanding of democratic government that gives greater leeway to the power of the presidency or the power of the executive branch. And actually, I might even say the presidency generally, because the case that I mentioned previously about overturning Chevron deference actually restricted the power of legislative agencies. But I think there is an emerging trend that puts more power in the hands of the president as opposed to Congress. So to take your broader point, I think you're right, it's potentially a question of democracy and checks and balances, but the current court potentially sees those checks and balances in a different way than the court has historically. And so you're right, it's not necessarily about liberal or conservative, but it's about deference to presidential power. And that's also kind of a new thing, because if you look at the New Deal era, when critics were calling Roosevelt a dictator and that this was a grab for power, and many criticisms, I've just been reading about this, so it's fresh in my mind, many criticisms that might echo around some of the criticism we're hearing about the current incumbent. Congress particularly, there was pushback against that within court decisions. So I think there is a changing thinking about where the checks and balances lie here. So I think that may be what's going. But we'll need to see how some of these other cases go. I hope that answers your question.
Thank you so much. I have two questions. First, you talked quite a lot about decisions that would technically be done in the legislative and then end up in the Supreme Court. And I'm wondering how much of this is also a critique of the legislative. Because I've done a little bit of work on civil rights cases, and there you often see this trend that there's a narrow decision first, and then years later there's a decision that's much more broad when the Supreme Court says, okay, legislative has not made a decision on this, Congress has not acted. So I'd be really curious about how much of this is really critique of a failing legislative. Mm-hmm. And the other, I'm not quite sure how to phrase this as a question. You've talked a lot about public opinion and how important that is for the legitimacy of the court. But if the public stops believing in the Supreme Court, as long as they're still believing in the executive and still believing in Congress, and lower courts are still believing in the Supreme Court, then life goes on. So I'm wondering how much we need to worry about the executive, especially now, and we could probably pull this further from the Supreme Court to lower courts as well, that they don't hold up checks and balances, that the power of the purse and the power of the sword is more of an issue within government than it is within public legitimacy or public opinion.
Yeah, it's an interesting point. And one I don't know if entirely I have an answer for, because I think it's something that I'm still trying to work out with the levels of the court. I agree certainly to the extent that sort of if you defer to the powers of the other branches of government and the public opinion continues to support what they're doing, there's a limit to how far courts can go. Right? There's always this discussion, has been recently, but historically too. What happens if the Supreme Court makes a decision and everybody goes, nah, not going to do, whether the public supports it or not? To draw on a different example from previous research. So in the 1960s, the Supreme Court says separation of church and state means you can't have mandated prayer in schools, right? And you can't have mandated Bible reading. That's too much like putting the power of the state behind requiring religious exercise. Students want to do it privately or after school or whatever, that's fine. But you can't do it. Huge backlash to that. What happens? Schools in communities that don't like the Supreme Court ruling just quietly carry on doing it, right? And it's an example, and there are occasional legal challenges to that, but often it's happening in religiously homogenous communities where there isn't anybody that's going to challenge it. So it's a really good example of how public opinion can resist the power of the court, even if there's a constitutional argument about it. You could argue actually that civil rights. Desegregation is a similar argument. You look at how long it took to desegregate schools, and arguably, of course, they're resegregating, albeit not as a result of legal lines. So you don't need a full-blown constitutional crisis for people to resist Supreme Court rulings. They can do it quietly behind the scenes. If nobody's going to bring a legal challenge, it doesn't hit the headlines, which I realise is slightly to the side of what you're asking me, but I think is sort of the closest I can sort of get at the moment in thinking about what happens if public opinion is supporting whatever else is going on. How does that fit? In terms of the first part of your question, absolutely, this is a critique of failing legislatures, and certainly has been since the middle of the 20th century. The reason Thurgood Marshall and the NAACP go to the courts is because legislatures are not just saying then that they think what they're asking for is a bad idea, they're simply not engaging with it at all. So they can't even get a foothold in the door in many cases. So the courts offer a potential, they come up with this legal strategy of challenging separate but equal, piece by piece by piece, and take it through that. It made sense in the context of the time. Potentially in the case of the law of unintended consequences, others have learned that lesson and used the courts in other ways. And there have certainly been, on both sides of the political aisle, in case anyone thinks that I'm just criticising the conservative movement on this, go through the courts, get the Supreme Court to give you a ruling, means you don't have to battle it out in 50 individual states, right? But it means that legislatures aren't given the opportunity to have those discussions. Legislatures sometimes are refusing to have those discussions. I would argue the Supreme Court has too much power, and I say this as someone who studies it, right? The Supreme Court has more power, not just than the framers ever intended, but really than it should have in a functioning democratic system. And it partly has that because people can't get the legislature, particularly Congress, to respond to issues. And so the only way they feel they can get things done is to go to the Supreme Court. But that then puts the Supreme Court further and further into the crosshairs. So on that, yes, I absolutely agree with you. The bigger context of this story is legislative failure on key issues.
Yeah, thank you very much for a thought-provoking talk. I have two questions. The first is, you mentioned at the beginning, of course, that the Supreme Court was considered the least dangerous branch because it knew it's the power of the sword and the purse. What, in your opinion, will happen or would happen, and this can be very soon, as you said, if the current administration, Trump administration, would not honor a decision against the president's unilateral competence to impose tariffs? People say then there would be a constitutional crisis, but what would that actually mean? Would it mean a series of impeachments when the next president does the same, then you go on and on, or what would that entail in your opinion? And the second question, it's a bit of a personal question, since you teach in a country that until 50, 60 years ago had the philosophy of parliamentary supremacy in the Westminster system. Of course, this has changed with the European Declaration on Human Rights, with the European Court of Justice, once Britain was in the EU. And I think the Supreme Court in this decision a few years ago, when Boris Johnson was censored for proroguing Parliament. So there's a stronger element now to this review. So, and other Westminster systems have moved a bit more towards the United States, but it's still not that strict. For instance, in Canada, there is a limited ability of legislatures and the federal parliament to override the decision of the highest court, of the Supreme Court, which is quite similar to the US now, in certain areas of the law, not on very fundamental rights like human dignity and so on, but on others. And wouldn't that also be more compatible with the real doctrine of checks and balances if a qualified majority could override, at least temporarily? And would that diffuse the situation a little bit? Because, yes, if there would be term limits, of course, then you would calculate differently who you appoint, but it wouldn't, I think it wouldn't sort of resolve the basic fractures in a very divided society. It would just make a different type of game. And of course, just as a final remark, I think that the Democrats probably would now think again when I think in 2010 or 2012 they decided to repeal the filibuster for judicial appointments to get Obama's people through. Not so much only on the Supreme Court, but on federal courts. And so should America look more on how other democratic countries deal with this issue of should an unelected branch at the end have the final word on constitutional issues?
Okay, thank you. Okay, to start with the first one first, what does a constitutional crisis look like? I hope we don't find out, but it's entirely possible. It's hard to say, and I say this as a historian who deals much more happily with what happened in the past than predicting what comes in the future. There are a number of potential possibilities, right? One is, say, the tariff ruling comes down and goes against the administration. Trump goes, well, I'm just leaving the tariffs in place. Let them do what they will, but I'm just going to ignore it. There are a number of potential possibilities. One is that spurs enough people, enough members of Congress into doing something legislatively that would take action. One is that nothing happens at all and people just kind of move past it and sort of this collective amnesia comes in and the Supreme Court continues doing what it does. Everybody just writes that off as one. Third one is that people come out on the streets and protest. I don't think they're going to do that about tariffs somehow. There may be some cases where people might protest. I don't think that it would result in sort of massive upheaval in the short term. What it means as a precedent for the next president and the next president and the next president would be an open question. And I think this is one of the questions about Trump, a different topic, but Trump versus US. It was a case that was decided in the context of a very specific political moment and in the context of a president whose behavior is so unlike presidents we've seen in the past. Now, if presidential behavior, should we say, after the current administration, there's a backlash or people just decide that they can't do the same thing, if things go back to the way they were before, Trump versus US becomes a historical footnote that was relevant to a particular moment in time and largely doesn't have massive legal consequences going forward. If presidents continue to behave in the way that Trump has, then it becomes a far more significant legal case. But we don't know yet because we don't know what's going. It would certainly, yes, it would be. To think about your second question, there are potentially lots I could say about this. One in which there is those of us who did not want the UK to leave the European Union are still clinging on to the European Court of Human Rights and everything else, despite the fact that governments continue to threaten to try and pull us out of it. So that's not as set in stone as many of us would like it to be at this current moment in time. The difference, I think, certainly between the US and the UK and the role of respective Supreme Courts, and I can't necessarily speak to some of the other countries that you mentioned because I don't necessarily know them in detail, but the difference here in thinking about parliamentary supremacy is the difference between a written and an unwritten constitution. So the Supreme Court can make a ruling, and in the British system, Parliament can pass a law which overturns it. Right? That can't be done. When the Supreme Court interprets the Constitution in the American system, that can't be done because it's the Constitution. If they overturn an ordinary law, so for example, had they just completely overturned Obamacare a few years ago, for example, Congress could have repassed it, at least potentially, which goes back to the earlier question about the failure of the legislature, right? And you can argue however you like about what the Supreme Court should have done about the Voting Rights Act and the way it gutted it a few years ago, but it warned Congress that it was coming, and Congress didn't do anything. So I think it links into that. So they are very different systems, which puts the Supreme Court in a slightly different position in those systems. The idea potentially of giving the public a way of either temporarily or permanently overturning unpopular Supreme Court decisions in the US, interestingly enough, is proposed in both the 1912 election and again in the 1930s. Neither of those proposals go very far, but in 1912 it's proposed by Theodore Roosevelt, who's running as a third-party candidate at that point. So this isn't coming from an out-of-the-way unknown figure who's trying to get their name out there, right? The idea of kind of recall of judicial decisions to allow the public, or usually with like a 2/3 majority vote, they're looking for a supermajority to do that, has been around. It's not new. It's never got very far, partly for pragmatic reasons, I think, and partly because other factors shifted attention away from them. But it's not completely new. Again, I don't know to what extent the American public would accept it, even if they decide they really fundamentally dislike what the Supreme Court's doing, again, because of this wariness of playing around with the Supreme Court somehow. But it's around and has been proposed historically.
There is, of course, a way to override constitutional courts, and that's amendment,
yeah.
But the U.S. system is so immobile. You need not only a two-thirds majority in both houses of Congress, but even a much bigger obstacle is the 3/4 requirement of verification by the states.
Mm-hmm.
I was just wondering, what's your take on this? I could assume, but this is a very radical idea. The constitutional scholar Irving Chemerinsky recently published a book, No Democracy, No Democracy Lasts Forever, and he argues, I think, quite convincingly that the American system is so broken that the American Constitution, which is after all comes from a horse and buggy age, is so dysfunctional that what America really needs is a new constitutional convention that would then come up with a modern constitution. I think it is probably a pipe dream, but I wonder what's your take.
Yeah, I think it's I certainly agree that I think it's a pipe dream, but he's been writing about this for a little while, actually, and he makes a really good case. I mean, it's an interesting discussion to have in the 250th anniversary of the Declaration of Independence, right? There are lots of things about the US Constitution that don't work properly, or don't work in the context of a modern nation. And do I think the US that it might benefit from sort of jettisoning the Constitution and starting again? In many ways, yes. In the current political moment, I wouldn't want to think about what they would get. But it's
never agree on anything.
well, that therein is potentially the problem. Maybe we all lock them back in the got in Constitutional Hall in Philadelphia for like 10 weeks with no air conditioning, and basically say if you don't come up with something, you can't come out again. Maybe that would work. Interestingly, though, the National Constitution Center, which is based in Philadelphia, and if you are interested in the US Constitution, the National Constitution Center is one of the most fabulous resources. It's non-partisan, has people from all sides of the political spectrum talking about all kinds of issues around the Supreme Court. I use it a lot for research, but also for teaching. They have had this project running for a little while about rewriting the Constitution. So they had 3 groups of people, libertarians, conservatives, and liberals, and said to them, okay, effectively, you are the new Constitutional Convention. What do you do? Right? You can do anything. So, it's not about what's pragmatic. What do you do? And none of the 3 come back and say, we're going to throw the Constitution out and start again. Which I think is really interesting, given what we often talk about the problems in the Constitution. They all tinker around the edges, and some have more significant proposals than others, but not a single one of them from any of those political positions says it is so broken we have to start again, even though in this context they could. And there have been follow-ups. There was one about what would you do to rewrite the Bill of Rights, which is also an interesting debate between those groups. So I would encourage you to go read the stuff on their website about how they do that, because actually it's quite enlightening as to how Americans who are, I think in many ways, brought up within the system of the American Constitution, some of the assumptions they make about it, that those of us who look at it from outside maybe don't.
Well, thank you so much. The good news is you'll be back to my
Well, indeed.
And I'm sure there is a lot more, and there are many more reasons to talk about the Supreme Court, the American Constitution, and the legacy of 1776, which is, of course, coming up, the semi-quincentennial. We thank Emma Long for this talk, and I wish you all